So once again, good afternoon everyone. Good afternoon, ma'am. So this is the presentation of Group 13. Our topic is all about the intellectual property and other legal issues for the entrepreneur. But first of all, I would like to introduce myself. I am Giancarlo Yubio Gomez and my partner Isabel Patricio. The content of this report are what is intellectual property, patent and the types of patents, the patent applications, business method patents, registration the trademark, types of insurance, contract conditions, and results of a contract breach. So first, what is intellectual property? So intellectual property represents important assets to the entrepreneur. Intellectual property should be understood even before engaging the services of an attorney. It must be protected from an unauthorized use. Intellectual property refers to the creations of mind. It can be invention. And there are four ways to protect intellectual property. First, patents on inventions, trademarks on branding devices, copyrights on music, videos, pattern, forms of expressions, the trade secrets for methods and formulas with economic value. So, what I need for a lawyer, or if you need a lawyer, since all businesses is regulated by law, the entrepreneur needs to be aware of any regulations that may affect his or her new venture. At different stages of startups, the entrepreneur will need legal advice, and that's very important. Entrepreneurs should carefully evaluate the lawyer needs before hiring one. And how to select a lawyer? So a lawyer, like many others in professional, are specialists not just in the law but in specific areas of the law. The entrepreneur does not usually have the expertise or know how to handle possible risks associated with the many difficult laws and regulations. A competent attorney is in a better position to understand all possible circumstances and outcomes related to any legal actions. Also, lawyer may work on a retainer basis, stated amount per month, 1 year, or year, and provides office consulting time. This gives the opportunity to the entrepreneur to all or to call an attorney as the need rises without incurring highly hardy fees. So next is the patents. So the patents is a contract between the government and an inventor in charge for disclosure of the invention. The government grants the inventor exclusively regarding the inventions for a specified amount of time. At the end of this time, the government publishes the inventions and it becomes part of the public domain, which will help in generating new ideas and even the development of a better product that could replace the original. Also, we have three types of patents. So first, utility patents, design patents, and plant patents. So here, the utility patents, a utility patent has a term of 20 years. Some example is fiber optics, computer hardware, etc. Also, utility patent issue for the inventions of a new law and useful process, machine, manufacture or compositions of a matter, or a new and useful improvement thereof. It generally permits its owner to exclude others from making, using, or selling the inventions of a period of up of 20 years from the date of patent. So next is the design patent. So the patent law provides for a granting of design patents to any persons who has invented any new, original, and ornamental design for an article of manufacture. A design patent protects only the appearance of the article and not structural or utilitarian features. And the last is the plant patent. A plant patent is an intellectual property right that protects a new and unique plant's key characteristics from being copied, sold, or used by others. A plant patent can help an inventor secure higher profits during the patent's protection period by preventing competitors from using the plant. such as hybrid tea roses, silver queen corn, better boy tomatoes, are all types of plant patents. So the next is the patent applications. So this patent applications is a request pending at the patent office for the grant of a patent for inventions described in a patent specification and a sets of one or more claims stated in a formal document. And also we have three way on how we write patent applications. So the next is the patent applications. So this patent applications is a request pending at the patent office for the grant of a patent for inventions described in a patent specification and a sets of one or more claims stated in a formal document. And also we have three way on how we write patent applications.
So up next we have trademarks. So trademarks are a distinguishing word, name, or symbol used to identify a product. So trademarks, unlike patents, can be renewed forever for as long as they are being used in the business. So in business terms, trademarks are like badges that represents a product or a company. So they distinguish goods or services of one trader from another, and they can be of many forms. For example, trademarks could be slogans, words, logos, shapes, colors, sounds. Trademarks are registered for specific goods or services with individual subjects known as classes. So, trademarks, patents, and copyrights are different in terms of what they are protecting or what they are deterring other traders to copy from another trader. So for patents protects new inventions or new processes, while copyright protects original ownership or authorship of a work, and trademark protects brands, logos, and slogans. So, in simple explanations, ang trademark is a sign, a slogan, or a color that represents a certain company or a certain brand. So, for example, nang magkakaroon ka ng problema when it comes to trademark is, for example, you're trying to package a beverage and call it Coca-Cola, or you are not trying to call it Coca-Cola, but you are trying to use the color of Coca-Cola to as a design for the beverage that you've created. So trademark goes further than just the logo or the slogan. So trademark prohibits any marks that may cause confusion to buyers. So for example, kaya nga nun, you are creating a beverage and you're trying to use similar colors with Coca-Cola, so it may cause confusion to buyers, that may cause them to buy your products thinking that it's Coca-Cola, but it's not Coca-Cola. So that's problem with trademark. So trademarks make sure na businesses can't use symbols that look similar, sound similar to a symbol that is already existing or is already trademarked by another company. Most especially if the products that you have or the products that you're trying to sell is very similar to the product that the existing company with the existing logo or symbol has in store. So for the next slide, we have registering the trademark. So this is the few steps that are needed to follow for us to register a trademark or for us to submit a trademark protecting a logo or a symbol that is representing our brand. So for registering the trademark, so first, Filing of the trademark registration must meet 4 requirements. So the first one is completion of the written form, a drawing of the mark, 5 specimens showing actual use of the mark, and of course the fee. Next, we have licensing. Licensing is an arrangement between 2 parties where one party has proprietary rights over some information, process, or technology protected by a patent, trademark, or copyright. So in simple explanation, licensing is a legal or a written contract between 2 parties wherein the owner allows another party to use their brand or their patent or their trademark to be used for the other party's business. So in this agreement, this agreement entails how the licensor or the owner is to be compensated, and it also settles any disputes related to sales, issues of qualities, and stuff like that. So, in short, in a licensing agreement, the other party is being allowed to use the brand or the trademark or the patent of the owner for his or her own revenue. So, a company that is the biggest example of a company that uses licensing for their own gain is the Walt Disney Company. So, they allow other distributors or other companies to, or they give other companies a licensing agreement to use their brand, their brand, their patents, their trademarks in any shape or form that would bring them revenue. So one example for this is for toy companies. They are given a licensing agreement to be able to use Walt Disney characters. Next up, we have types of licensing. So there are 3 types. The first one is patent license agreements. Patent license agreements specify how the licensee would have access to the patent. So the licensee may either just market the product or manufacture and sell. So in patent license agreements, this gives the licensee access to patented inventions. So they have the option to just sell the product, or they can choose to manufacture it using their own materials and sell it. So depending on what the agreement is between the licensee and the licensor or the owner of the patent. The second one is trademark license agreements. So this involves a franchising agreement wherein the entrepreneur operates a business using the trademark and agrees to pay a fixed sum for use of the trademark, pay amount on sales volume, and buy supplies from the franchisor. So in this license agreement, the business owner or the entrepreneur is going to be operating a business that is using the trademark of the company they have made an agreement with. So this involves a franchising agreement because since they are operating a business using the trademark of that said company, so they need to be selling merchandise from them. So they have to buy supplies from the franchisor for them to be able to sell products under that trademark. For example, I am an entrepreneur under a trademark license agreement with Nike. So it would also involve franchising because, of course, I am operating a business using the trademark of Nike. Then, of course, I have to buy merchandise that is also from Nike. It would be a hassle if you're using a trademark of one company and selling merchandise from another. And the third mark is copyright license agreement. So this involves right to use or copy books, software, music, photographs, plays, etc. So in copyright licensing agreement, so this gives the licensee the rights to be able to use a certain music, certain photos, gives them access to copies of books. This goes, for example, to music artists. So they earn by using copyright license agreements. For example, I want to use this singer's song as a background music for a project that I'm trying to make. So I can use a copyright license agreement to have an agreement with the owner of the song that I would use the song or his or her song for my project, and in return, I will pay them for using the song. Up next, we have insurance. So, insurance is a promise of compensation for specific potential future losses in exchange for a periodic payment. So, there are different types of insurance. There are healthcare insurance, car insurance. So, technically, insurance is a security for our assets in case of any losses or any unfortunate events. So, an example I could give for this is, for example, healthcare insurance we have here in the Philippines. There are private insurance and there's a government insurance. So, for government insurance, let's say, for example, we have PhilHealth. So, PhilHealth is a healthcare insurance wherein we make monthly payments, and in return for those monthly payments, in case of an unfortunate event that either you yourself or a beneficiary of yours get sick, so they will cover part of your hospital bills, but they're not going to cover the bill as a whole, just a not technically small, but a percentage of it, so that you don't have to pay the whole bill out of your own pocket. For types of insurance, we have property insurance, which provides possible coverage for our personal properties. Next is casualty, which provides insurance for possible physical injuries or property damage. So it is applicable to fuel stations, superstores, and shops. Next is life, which protects the business continuities, especially a partnership. Next is workers' compensations, which provides benefits to employees in case of on-job injury. So this is applicable to chemical and manufacturing industries. Next is bonding, which protects companies in case of employee theft of funds or protects a contractor if subcontractors fail to complete a job within an agreed-upon time frame. Up next is contract conditions. So it means an offer is made, it can be oral or written, but it is not binding until voluntary acceptance of offer is given. So a very basic example of this is a work contract. So a contract is where the conditions of your work is written in. So it includes your work hours, your salary, what is expected of you by the company, and what you can expect from the company, and other specific details that is both beneficial to you and the company itself. So, an advice I can give is that never sign any written document or contracts without reading every single line of it, to be able to protect yourself from agreeing into something that you haven't properly understood or you do not properly understand what it entails. Because you might sign a contract that is solely beneficial to the company and does not give any benefits to you. So that is something that you cannot easily get out of once you've already signed it. Up next, results of a contract breach. The party in violation of a contract may be required to live up to the agreement or pay damages. If one party fails to live up to its end of a contract, the second party may also agree to drop the matter and thus not live up to the agreement as well. This is referred to as contract restitution. So for the first bullet, so if you are in violation of a contract that you have agreed on, so there are two options for you. You are either going to be required to live up to your end of the agreement, or you are going to be obliged to pay for the damages that your actions of not fulfilling your end of the agreement may have caused. For the second bullet, if you are no longer fulfilling your end of an agreement that you have signed on in a contract, so the other party or the second party may just also agree to drop the matter and just not fulfill his end of the agreement as well. So this is in turn referred to as a contract restitution. So in this, you would not be required to live up to your end of the agreement, and you would also not be required to pay for the damages. You and the second party of the contract will just cease fulfilling both ends of the agreement, therefore ceasing the contract itself. Thank you all for watching. I hope that you have learned something from our discussion. If you have any forms of questions and clarifications, please feel free to message either me or Giancarlo. And again, thank you all for listening.